Okay, let's kick off and people will join as we go. Thanks very much for coming to the second of our 101 series, this time on data and privacy. Please feel free to ask questions at any point, and there'll be time for via the chat, and there'll be time for Q&A at the end. So privacy, gone are the days when privacy was a tick box function tucked away in a legal department. The use of data is now central to your businesses, creating growth, underpinning consumer products, maximizing advertising revenue, and measuring the effectiveness of campaigns. So let's get started. What are we going to cover? We're going to be looking at privacy through an operational lens. Too often, I've seen one of two general approaches to talking about privacy. Either people start with the privacy principles using the language of the legislation to explain, or they start with the technology to analyze data flow using technical language to explain. And the problem with that is that the legal side and the practical side often don't join up. Different languages, different cross-functional groups, too many black holes. And anyone who has been asked in their workplace to just check there are no privacy issues in the business will be all too familiar with those black holes. So today I haven't started with the legal framework, but I'm going to start with some key concepts. The meaning of personal information, de-identified data, and consent. And for those of you from the policy side who are interested in how government might be approaching reform, it's really important to understand those issues conceptually. Then we'll have a look quickly at the Australian privacy principles, but again, from an operational perspective. So I'm not going to go through all 13 principles, but what I will do is look at the life cycle of data. So there are the three main stages of collection, use, and disposal. And so looking at data and privacy as your business looks at data. And then we'll finish with some practical use studies, some tips for good practice, and the upcoming reforms. Now, the reforms are important. Remember, this webinar is going to look at privacy as it is now, although the concepts, as I say, are really important foundations for anyone who needs to assess government reforms. The second set of reforms, Tranche 2, when they come, will change the framework that we're operating in. But throughout this presentation, I will try and flag where that seems to be likely and the areas that we need to keep a particular eye on. Now, the last comment I wanted to make is if you have audience and customers in overseas markets, as many of you will, you do need to understand the legal requirement in those jurisdictions. And you'll need to also make sure before transferring data overseas that those markets protect it to a standard that's equivalent to Australia. Now, we won't be covering that in any detail today, but it's just worth you bearing that in mind. So first of all, what is privacy? There is no definition in law. So when you're talking about it internally, or for those of you in the policy world, when you're talking about it with stakeholders, it's important to understand and to make sure you're talking about the same thing. The type of privacy we are interested in as a digital, as businesses that use digital advertising is privacy of PI and data. Europe, by the way, tends to talk about data protection, but we tend to call it privacy in Australia. It's the same thing. Now, there are many different types of privacy, and it's worth just briefly thinking about the other types, just because I think it helps you to understand that context and consent are really key. So one that we're all aware of is privacy of the person. So that's personal space, touching, etc. So we all know that there are circumstances where touching someone is appropriate, circumstances where it is not, and that consent is key. And so how you interact with someone physically will depend on the context and consent. Similarly, privacy of behaviour with surveillance. It is sometimes reasonable to monitor and record people's behaviour, but again, depends on context and consent. So I think once you get in, when you get stuck in the weeds of privacy, and there are many privacy weeds, it's worth stepping back and thinking about, one, whether the use of the personal information is reasonable, and two, if not, has the person consented to the use? And they are exactly the questions you ask in those other spheres of privacy, personal space, surveillance, etc. And those are exactly the questions that our privacy framework and our policy reformers are setting out to look at. Why does it matter? As I said at the outset, privacy is no longer just tick box legal stuff. In fact, it's probably less important to lawyers in a way now than it is to commercial teams and product people. So the key issue is customer experience. The debate around privacy is often portrayed as being polarized, with the interests of businesses on one side and consumers on the other. But I firmly believe it's better to view this through a lens of alignment between business and consumers. Businesses want to provide the best possible experience for consumers to enable retention and growth of the customer base, and consumers expect streamlined user interfaces, relevant advertising, ad-supported content, secure data transfer, fraud prevention. And those expectations are only getting greater as we see the use of generative AI and inferential consumer content, or content based on inferences. So a better consumer experience and enhanced trust tends to lead to loyalty, better products and services, and in short, to better business. So it's really important that your businesses understand that. It's really important that we as an industry make it clear to government as well that consumer and business interests are in so many respects aligned. So I mentioned at the outset we would talk about key concepts. Now, it is really important that you understand these, both for the now and for the future. So the first one, which is fundamental, is what is personal information? We talk about it a lot, abbreviate it to PI, but what is it? It's any information or an opinion about an individual who is identified or reasonably identifiable. Now, there's a couple of really important points there. It's all information about an individual, even if it's totally benign. So there is no threshold that the information needs to be private or, in any way confidential. It is any information or an opinion about an individual. Companies do not have privacy rights. Now, the really important point here is it covers information where the individual is reasonably identifiable. So an individual is identifiable when the information being used can be linked with other available information to identify that person. So you always need to consider what other information is available. It may not be enough just to delete someone's name, email address, phone number, personal identifier. And we will talk about that later because that's a really important practical point. So the different types of PI. As we just looked at, PI is information or opinion about an individual who is identified or identifiable. PI is a subset of data more broadly. So you can see from these concentric circles, you've got the pool of data. Within that, you've got the pool of personal information. And then within the universe of personal information, we have a smaller pool of sensitive information. which is racial, ethnic origin, political opinion, religious belief, health information. So remember, that's quite broad. It is not, as some people think, just health information. So health information is an even smaller pool of information, which is information about your health, disability, and use of health services. Now, I will mention this later. I will mention it now because it's really important, I think, to remember. You can inadvertently use sensitive and health information. And one example would be if you are using a pixel or tracking technology that is monitoring the websites that a user visits, and they visit, for example, a counseling website or a website for gambling addiction, that you are conceivably accessing their sensitive health information. So just be really aware of the inadvertent ways that you can do that. And we will talk about that in more detail. De-identified data. When I have spoken to businesses, I often hear that people think that the privacy issues have been resolved because the data has been de-identified. Now, in a sense, that's correct. If it is not possible to identify any individual from the data, then it will not be PI. So if you think back to, your big pool, it'll be in this external black ring. You're not subject to any of the privacy rules. But this is often very difficult to decide in practice. One example, several years ago, a Harvard professor, as an experiment, managed to re-identify the names of 40% of allegedly anonymous participants in a DNA study. And the professor did this by looking at other available information. So if you look at the slide, the first possibility, when you're looking at de-identified data, what does it mean? The first possibility, where data identifiers have been removed, for example, names and addresses redacted, that is not enough in many circumstances. The second is what you need to look at. You need to look at data, it will only cover data where it is not possible to re-identify any individual. So in other words, if the individual can be re-identified by any means, including by matching the information that you have with other available information, it will not be properly identified and it will be considered PI. So if you take nothing else away from today, please remember that. Now, how do you assess whether your data has been de-identified? The OAIC, which is the privacy regulator, so the Privacy Commissioner, Carly Kind, heads up the OAIC. They have made it very clear that they will look at other information when they're working out whether data has been de-identified. And they have also made it clear that they will look for a very low risk of re-identification. So you need to check really carefully what other information might be available to enable identification. For those of you who are working with government on this, this is also an important point from a policy perspective. It's important that government understands some of the complexities that business faces when faced with a requirement to de-identify. It is not simply a case of removing names, but it can, in some circumstances, impose a really high threshold for businesses that may not be practical. So within your business, when someone tells you that they have got de-identified data, so it is not PI, so the privacy regime does not apply, what questions should you ask? And you will always need to ask questions. And this comes back to that point I made at the beginning about privacy now spanning so many areas: legal, technical, product, commercial. There is no single person in that chain who knows all the answers, no one. So Another thing that please take away, when you are talking about privacy within your businesses, don't be worried about sounding silly. You need to ask questions. Every single person in the cross-functional group needs to ask questions. So here, ask what de-identification techniques have been applied to the data. If you're a lawyer, make sure it's in language you understand. Don't feel silly about asking a tech person to drill down. Similarly, if you're a product person, make sure you understand from your legal people exactly what they need. Understand the nature and the amount of the information that has been de-identified, who will have access to it, and importantly, what other information those people have access to. So that might be information that you as a business are giving, or it might be publicly available information. But you need to focus on the practicality of them using that information to re-identify or to find out new attributes for that person. Online identifiers. This is a little subsection to de-identification. Now, online identifiers are currently used as a means, or one of the reasons they're used is a means of avoiding the use of PI. So an individual is identified by effectively a label, like a code or a number, in place of their name. Now, as part of the reform process, the privacy reform process that government is undergoing at the moment, policymakers have been looking at whether to expand the definition of PI to include online identifiers. Now, I want to make it clear they have not done this yet, and nor have they told us they are going to do it, but it is a possibility. So this would mean, if it happened, that online identifiers could be classed as PI, even if you can't link the identifier, so the number or code, the label, to a named individual. So in other words, you'll see the second bullet point on the slide, can harm take place where people are distinguished from the crowd, is the phrase that is often used, even where their ID is not known. And other jurisdictions like California and Europe have taken the approach that the answer to that is yes. So the current assumption that you can't suffer harm if you can't be identified is being tested by the digital economy. The digital breadcrumbs, the geolocation data, the patterns of behavior we exhibit online when we click, share, like, they all enable a type of tracking without identification. So it is possible that Australia could reform the law to catch the use of these sorts of online identifiers. And again, we as an industry need to explain the impact that could have. Practical steps, de-identification. Be careful when people talk about de-identified data and look at the context in which the data is held and used. Now, the OAIC, the privacy regulator, has suggestions to reduce the re-identification risk. And can I just say, the OAIC website, I think, is an excellent resource. So it's always worth going there if you need detail or guidance. So they suggest limiting access for information, really good suggestion in all areas of privacy. Don't collect stuff you don't need. Allow access via a secure mechanism, like a data lab, for example. Analyze the data rather than accessing it, or rather enable analysis rather than accessing it. So you provide the result rather than the raw data. So that can help, although remember, if it is capable of re-identification, that could still be problematic, but it should help. And then just some practical commercial steps. So require the person you're sending the information to sign a contract limiting what they do with the information. So for example, include a provision that that person will not attempt to re-identify the information. So that will protect you. If they do the wrong thing, then they should then be liable for that. So that's a good commercial solution to some of these problems. So that's de-identification. Second concept, sorry, it's the third. The first was PI, then de-identification. Third concept is consent. Now, consent is often talked about in the context of privacy, probably more than anything else, actually. And that will be the same whether you've got a commercial role in your business, whether you're doing the product, whether you're doing the tick boxes, or whether you're in the policy world and you're talking to government about consent of consumers. Before we talk about what consent means, remember, you do not need consent currently for most activities. And I think a lot of people don't realize this. You only need consent at the moment if you're collecting sensitive information. So remember that chart, the bullseye chart with those concentric circles, or if you're using or disclosing data beyond its primary purpose and outside customers' expectations. And I just want to pause there for a second, because customers' expectations is another theme that will keep coming up in the privacy world. So if what you are doing is within customers' expectations, it will often, not always, but it will often not need consent. So always have a think about that. So you will only need consent if it's sensitive or you're doing something outside their expectations. When you do need consent, what does consent mean? Opt-in, opt-out, specific, privacy policy, what does it mean? And this is a really big practical issue for people. Now, you'll see 5 words on the slide. Consent means to be voluntary, informed, specific, current, and capacity means the person consenting needs to be able to. So in other words, be careful if it's a child, or if it's someone from a vulnerable group. But what does this mean in practice? Voluntary is reasonably straightforward, although do be very careful if you are requiring consent in order to access a service. Sometimes that's okay, but sometimes it might not be. Informed is the key one. This is where a positive opt-in is often the safest. Important to understand that getting a customer to agree to a privacy policy will not usually be valid consent. You need something more than just a compulsory acceptance of a privacy policy or standard terms and conditions. Again, along a similar lines, it needs to be specific. So general or bundled consent can be problematic as well if you are getting consent for a number of different services. So be really careful about that. And it needs to be current. You need to inform people how long you're going to rely on it, and enable them to change their mind. Capacity we talked about, which is be careful when you're talking about children. So consent, be careful in the relatively limited circumstances when you need it. You need to make sure it is proper consent. Remember, just having it noted in your privacy policy is not enough. Now, Australian privacy principles, and this, when you go to courses or lectures or webinars on privacy, this is often where people will start when they are taking a legal focus. Now, I am not going to get, there are 13 Australian privacy principles. People often shorten Australian privacy principle to APP. There are 13 of them. Yes, they are all very worthy and they make sense, but they are long, they are legalistic, and they are hard operationally for someone who is not a lawyer to interpret and implement. So what I have not done is give you a list of the APPs. What I have done instead is to simplify the APPs, so these principles that you need to observe, into broad categories to reflect the life cycle of the data. And again, for anyone on the policy side, when we're looking at reform, it's really useful when you're talking to government to just keep coming back to this practical life cycle. So 3 main stages. You collect the information, then you hold and you use the information, and then you dispose of the information. And different principles and rules apply to each stage. And I've just summarised on the column in the right there the rules that you need to be looking at each of those stages. So let's look at these stages in turn. First, collecting the information. The principles say, and I'm going to do this at a very high level, otherwise I will lose you all and you won't remember. So just try and remember the basic principles. The OAIC has a lot of detailed information if you're on the legal side and you need that. Allow anonymity if possible. The information must be reasonably necessary for your functions. Now, that's a really key thing to remember about your data use. It needs to be reasonably necessary. And again, for those on the policy side, when you're looking at government's proposals to have some reasonableness, reasonable and fair criteria, threshold, some of that already exists here. It needs to be reasonably necessary. It needs to be lawful and fair. So the OAIC gives multiple examples of lawfulness and fairness. The key one is really just not collecting by deception. So make sure you're transparent and not misrepresenting the purpose of the collection. Don't say you're collecting it for one thing and then use it for another. First party data, really important, increasingly important. You must collect directly from the person unless it's unreasonable to do so. And there are special rules for collecting sensitive information, which we've already mentioned and we'll go through again where you need consent. Now, importantly, collection notices. When you collect information, you need a collection notice at the time you collect it. So that needs to explain the type of information, whether it's mandatory to provide it, and the consequences of not providing it. Now, you can refer to a privacy policy on sort of common topics like complaints processes, but it is not enough just to have a privacy policy. You need a collection notice. So for those of you particularly involved on the policy side, when we talk, and we often do, about wanting an outcomes-based framework rather than a process-driven tick box one, this collection notice point at the moment is a process that it's a hoop that everyone needs to step through. And you may have views on whether or not that's a good or bad thing, but this is a hoop which actually you then combine in some circumstances with the consent. But the collection notice is one of the reasons as a consumer you keep getting pop-up boxes and notifications. Remember, it includes what's called collection by creation, which is inferred data. So that obviously a lot of you do all the time. You're inferring data about a customer rather than them giving it to you. That is still a collection that needs to comply. So that's a really that's a really important practical point. Be careful if you're drawing inferences. And again, particularly if that relates to sensitive information, and you'll remember the example I gave of the counselling website, for example, if someone is visiting a site like that. And lastly, your collection notices do need to be short and easy to read. It's also important to remember that neither collection notices nor privacy policies are mechanisms through which you gain consent. So when you're looking at the processes you need to follow, your collection notice is one thing, your privacy policy is another, and your consent is a third. And you do need to tick off on each of those individually. Consent only if you need it, but if you do, that's a separate process. So you start to get a picture of, how cumbersome the current regime is, and why as a consumer you are faced with a lot of tick boxes, which many people believe leads to consent fatigue and doesn't really benefit consumers or industry. And that's one of the things government's looking at. Then you move on to holding and using the information. Really important, only use the information for the primary purpose for which it was collected and for a directly related secondary purpose. So again, we come back to this theme of if you do something unexpected, you need consent. You can use, there are exceptions when the data is, when you're going to use the data for a public interest reason, but be careful. That tends to be things like law enforcement, not marketing activities. Direct marketing, just very quickly, there is a separate principle about direct marketing, which really reflects a lot of what we've talked about. But the basic rule is you can use your first-party customer data for direct marketing without consent if you collected the PI from the person directly, the information isn't sensitive, and they would reasonably expect direct marketing. You also need a simple unsubscribe and opt-out mechanism. So again, we've got those key themes of reasonable expectation. Is it reasonable for you to be using the data in that way? So that's all I'm going to say on the APPs. Practical steps. APPs, the privacy obligations cover the entire life cycle of the data. You can't infer consent through your collection notice or privacy policy, but you need specific informed consent. Remember, you don't need consent for most users, and one of the key questions you need to ask is, would your customers expect this use of their data? So again, these key themes, would the customer expect the use? If not, you might well need consent. Quick overview. I'm not going to dwell on this, but just so you are aware, there are a couple of other pieces of legislation in Australia, the Spam Act and the Do Not Call Register. The Spam Act applies to emails, SMS and instant messaging. You do need consent to send any of those, and that consent can be express, opt-in or inferred, and you need an unsubscribe. I think most people are pretty familiar with that. Do not call register. Again, I think people are familiar with the obligations. You need to wash your data to make sure that you are not calling a number on the do not call register unless you have their consent or if an exemption applies. And then lastly, GDPR. GDPR, everyone is familiar with. It's a set of harmonised privacy laws across the EU. The reason so many people in Australia are familiar with it is because it does have an extended reach outside Europe if you are offering goods or services or monitoring the behaviour of people in the EU. There are huge penalties, up to $20 million, 20 million euro, or 4% of global turnover. So it's worth getting right. And as you'll all know, a lot of partners insist that you are GDP compliant, even when you're based in Australia. So they are, just so you're aware of that. We're not going to go into those in any more detail because they don't massively change the substance of what we are talking about. One comment I would make about GDPR is that for anyone who has European subsidiaries, affiliates or partners, you're probably aware that there are increasing discussions about the burdensome nature of GDPR and the way it is in some ways limiting growth and productivity. So it's interesting to look at GDPR, and we need to make sure in Australia that when our privacy law is reformed, that we learn from some of the issues that GDPR as a first mover has come across, and we make sure that we have a streamlined system that works for consumers and businesses over here. Practical case studies. I'm now just going to talk about 3 questions that you all might get asked in your business that link commercial use of data with privacy regulations. The first is a super simple one, collecting contact details to add a customer to your marketing database. Now, the reason I've included that is because I've actually many times been asked the question of, I've just come from another business, I've got this database, can we just combine it? Or can we combine a database for this purpose, one part of the business, with a database another part of the business has, so that we can reach more customers in an EDM, for example? Now, the answer to that is usually no. So going back to our life cycle of data, what are we looking at here? We're in the collection phase of the life cycle. So we need to look at the Privacy Act and the Spam Act. And again, we're coming back to those key themes. The collection must be reasonably necessary for the company's activities. The means of the collection must be lawful and fair. The data must be collected directly from the person unless it's unreasonable to do so. And you need a collection notice at the point of collection about what is being collected and how it will be used. So I hope that's starting to feel familiar again by now to you. The Spam Act, just remember, it is unlawful to collect addresses that have been sourced with address harvesting software. So the days when you could scrape contact details from the web are well and truly long gone. Practical steps when you add contacts to your database. Only add people to your marketing database if you have a direct relationship with them, because that is the way that you satisfy that would they expect it, and is it reasonable for your business functions? And you remember that comes up in the principles that you need to comply with. Do your collection notice. Tell people at the point where you collect their contact details that you will be putting them on your mailing list. Take them off your mailing list when they ask you to do so, and don't buy or use third-party mailing lists. So one of the key points here to take away is do talk to people within your organization about it. It's a classic example of the case where someone thinks they're helping by combining two marketing databases to increase the audience for an EDM without realizing that this might not be permissible because you've not given the proper notice and you've not explained to people what you're going to do with the information. So that's quite straightforward, but just super important to remember. Case study 2, a little bit more complex, creating a customer profile. So this is what we all like doing. This is the core of, many of our businesses. We use the data to profile the customer so you can tailor marketing to them through a personalized ad or email. So you might want to segment customers into different categories. You might want to analyze purchasing histories to decide what products to suggest. You might want to infer information about a customer from their social media activity. And remember, inferring information can still be personal information. So what does the Privacy Act say? Spam Act doesn't kick in here, so we're looking at the Privacy Act. Inferring and generating new data is collection by creation. So the same rules apply. We're back to reasonably necessary. Must be reasonably necessary for your company's activities. Any sensitive information needs consent. Means of collection must be lawful and fair. First-party data, the information must be collected directly from the person unless it's unreasonable to do so. And you need a notice of collection about what is being collected and how it will be used. So again, similar, which I hope is reassuring. So practical steps when you're creating a customer profile. Use first-party data. So you can use your customer's history of purchases with your company for profiling, as long as your customer would expect it. Provide a notice at the point of collection explaining what is being collected and how it will be used, and don't use sensitive information to profile or segment. Those examples we've talked about inadvertently using sensitive information, make it high risk because it is very difficult to carve out those possibilities. I was thinking it was St. Patrick's Day recently. If you target Irish people on St. Patrick's Day for let's not go near alcohol because that's a a more sensitive product, but for a fluffy shamrock or something, you know, you are using information about their race, which is potentially sensitive. So it doesn't have to leap out at you as being sort of a nefarious or private. It can cover a huge range of information. There's also information, you need to be careful about information that may not come technically within the sensitive information definition, but which brands often will not want you to collect, being inadvisable from really a brand safety perspective. So for example, in finance, any categories based on low credit scores, you know, the brand safety considerations of that, a lot of finance companies would not want you to do that. So the brand safety considerations can sometimes be more conservative than the regulatory restrictions. So really, really important to think about that as well. You need clear consent. So remember, separate consent, not just your privacy policy or your collection notice, for the use of any second or third party customer data to enrich profiles. And you do need to mention in your privacy policy that you collect PI by inferring and generating data. So just think very carefully about when you are collecting that sort of data and when you are profiling a customer. Be aware this is an area that when we get our new privacy laws, this might well change. But for now, this is the law. Using tracking pixels, I thought was definitely worth a mention for a few reasons. It's worth people on the policy and legal side in particular really understanding what we mean when we talk about tracking pixels. If you're on the industry product side, you probably understand what it means, but you need to understand just how sensitive it is at the moment and where the current law sits on it. People often talk about the reforms and say third-party tracking pixels are going to be banned. May or may not happen. Let's look at what the law is right now. So first off, what's a tracking pixel? Piece of code generated by a third-party provider that can be placed on an organization's website to collect information about a user's activity. Now, some of you here will know far more detail than that. If you don't, that's probably all you need to know to understand the basics. And for those of you on the policy side, it's really important that people you speak to in government understand that as well. So when a user visits a web page with a tracking pixel, the pixel loads and sends certain types of data to the server of the third-party provider. How are pixels used? To analyze web traffic, visits, time on a page, user demographics, to target ads to users of third-party platforms, and that's the one that often gets the most attention, but it is not the only use. Measuring success of campaigns and validation, really important use as well. So are you allowed to use them? Well, collection of PI for pixel usage is currently permissible where the collection is reasonably necessary for your organization's activities. So again, the reasonably necessary rule. Now, although it is currently acceptable to use tracking pixels, it does not mean that the Privacy Commissioner likes it. So, and she has been, public about this. So it is worth being very cautious, and the OAIC, the regulator itself, recommends you are cautious. So you might remember the big pixel debate just over a year ago, when the Privacy Commissioner published an opinion piece in the Australian newspaper discussing the fact that TikTok, like other social media platforms, it happened to be TikTok, but could have applied to many, not just social media either, receives personal information about users as they move across the web. And that data can range from the fact of a site visit to email addresses and mobiles. So the Privacy Commissioner said in the article in the Australian, and I quote, "I will be the first to say these practices are unacceptable. These tools underpin a digital ecosystem driven by the business model of advertising, wherein brands keen for our attention pay a premium to platforms that know enough about us to deploy the right ad at the right time. And the Privacy Commissioner highlighted not just platforms, but also shopping outlets, news media, health providers, educational services, and other online services that use tracking tools. Now, I don't want to discuss the whys and wherefores here of are tracking tools a good or bad thing, but I think everyone would agree that they do have an important commercial business function, and it is really important that anyone regulating privacy understands this. So what types of personal information might a pixel collect? Transaction data, such as items viewed and cart additions, so that can help streamline the customer experience. Form imports, name, address, date of birth, email address, and phone number. Again, that can help to streamline customer experience. Network information like IP address, geolocation data, which is, that's the subject of some discussion, URL information, and other activity data, pages visited, content viewed, session duration, etc. Now, I mentioned when I started talking about pixels that the regulator recommends a cautious approach, and I'm just going to quickly tell you what they have said about this. They have said it may not always be clear whether the data collected and disclosed through a tracking pixel is personal information. Given the potential privacy risks and significant community concern about the use of tracking technologies, the OAIC strongly encourages organisations to err on the side of caution and comply with the Privacy Act when using third-party tracking pixels on their website. Now, that might not be a great deal of practical help to you because it's just telling you to be cautious. But the reason I'm highlighting it is what it does tell you, which is really important, is that the regulator is looking at this and the regulator has some concerns about this. And the comments on the TikTok case suggest that certainly at that time, the regulator was questioning whether the current law went far enough. So practical steps. First, understand how your product works, identify the risks, and implement measures to mitigate. And how do you do that? Easy to say, how do you do that in practice? This is similar to your de-identification issue. Talk, know your internal stakeholders, talk to them, understand it, don't be afraid to ask questions. Usually it's the person using the pixels that will be liable for compliance, not the third-party pixel provider, so make sure you get it right. A practical step which is useful is reviewing the terms of agreement with your third-party pixel provider so that you understand your obligations and they understand theirs. Be clear and transparent about your use of third-party tracking pixels. You'll remember one of the principles that comes up time and time again is fair and lawful means. So don't do anything that looks nefarious or secretive. Be clear and transparent. Avoid collecting sensitive information. Remember those direct marketing obligations, comply with those if you're using pixels to target individuals with advertising. So again, it needs to be reasonable use and reasonably foreseeable. And conduct regular reviews of your tracking technologies on your website. That's really important, so you know what's actually happening. I've just listed here the questions that it is worth asking when you're using pixels. So what information will it collect? Will any sensitive information be collected? How will the third-party provider use and disclose the PI? Will it use the data for its own commercial purposes or share it with other entities? Big red flag if so. How will the information be secured and how long will it be retained? Just make sure that you know when information, that you know how long someone is going to keep the information. So you don't want it just sitting somewhere for 5 years. And that happens more often than you would think. You need to consciously make sure that everyone is aware of the time, and that the third party has appropriate processes in place to protect PI. So look, that is the main, the bulk of today's presentation on the information flow, the operational interaction between the privacy regime. Very quickly now, just a summary of tips for good privacy practice. I do need to mention privacy impact assessments, which many of you are probably already doing. And actually, I've had chats with people who are doing it without even realizing they're doing it. So, I will say, what are you doing in terms of your privacy and your data? And, people might say, well, we're mapping where the data flows, we're making sure we've got consent where appropriate, and we're having lots of cross-functional meetings. Well, that's perfect. You're actually a long way down the road of doing privacy impact assessments. So you should, as a matter of good practice, conduct a PIA before new projects. It'll describe how your data flow. And that's good practice for you actually in terms of your product work as well, just really thinking through the detail. Analysing impact on individuals' privacy and providing recommendations for minimising or eliminating the privacy impact. So that means you can build privacy considerations into your project design. The OAIC recommends that companies do this, and so it can help to protect you. If you have any privacy investigations, it's good to show that you've done it. Now, the OAIC has really good tools on its website for PAIs, and it has a template. It does suggest that organisations make the PAI public. Now, I see where it's going with that. It is good for your consumers to understand you've thought about privacy and the privacy implications, and you might well want to communicate that. Just be aware when you're further back down the track, when you're sorting out your product design and when you're looking at risks, it is probably important for you to involve a lawyer so that your communications at that stage remain what's called privileged, so that they can't be disclosed in court. So if you sound worried about this, would this be a breach? That remains private to your organisation, as long as you've got a lawyer there and it is all done as legal. Ask your lawyers about that, and they can give you the detail. But just remember, you do not want those sorts of conversations to be open conversations. They're seeking legal advice, and you need to be careful. So tips for good privacy practice. We've spoken about all of these already. Do a PIA, design your products to minimise privacy risks, look at privacy at an early stage. You need a privacy policy. Collect de-identified data where possible, but do not assume that's a cure-all, which we've spoken about. Request consent for sensitive information, new users, sharing of PI, and obviously where your customer is not going to expect that use. Check privacy practices of third-party partners. Collect your PI directly, first-party data where possible. Notify individuals when you collect PI. Look after the PI you hold, keep it secure and protected, and regularly dispose of PI that you no longer need. It's so important. So many data breaches come because companies keep the PI longer than they need to. So in the last couple of minutes, what does the future look like? I can talk for hours on policy and privacy reform. So anyone who wants to talk about this in more detail, give me a bell, but just so you know the basics. We probably all know that there were a set of privacy reforms about 1.5 years ago, which people often call Tranche 1. Tranche 2, the second set of reforms, is yet to come. Government just around the time of the Tranche 1 reforms did make some I think it was AGD. Anyway, there were some recommendations. We are now quite a long way away from those recommendations, so I think it's probably fair to say at the moment we don't know exactly what tranche 2 will be looking like. So it will be very interesting to see what is on the horizon. Probably fair to say there's an increasing focus on productivity and growth, and making things reasonable for businesses as well as protecting individual rights. Browser level bans on third-party cookies is a possibility, and a focus on general harms, fairness and reasonableness, children location data, possibly rather than this prescriptive tick box notification consent regime. A broader definition of PI, as I've talked about, is a real possibility when we're looking at what protection, de-identification or unique identifiers give you. That might change. And the last general theme is that consumer protection and privacy regulators are increasingly joining force as the lines become blurred. So a great example of that is personalised pricing, which in part involves privacy issues, but in part involves consumer rights issues. So it'll be interesting to see where those issues end up sitting. So look, I think with 2 minutes to go, I will leave it there. If anyone has any questions, please shout, and I think Gay is going to manage that part.
Yeah, thanks, Sarah. Perfect timing. We will share a link to this recording and the deck, which is often the most common question. So that will go out to anyone who registered. Sarah, I'm sure you will get lots of direct questions. One just from me in these last 2 minutes, the tranche 2 coming at some point. A lot of people seem to be waiting to update their systems, their processes. What's your, I guess, comment on best approach there?
Look, great question. And 18 months ago, I would have said, let's just hang fire, wait and see what happens. There is no point in spending time and money on updating systems right now. I think we've moved on from that. The Privacy Commissioner, rightly so, is enthusiastically enforcing the current law, and that's their job. That's all they can do. So we do all need to, I think, review our systems at the moment and make sure that we are compliant. It's really important. We can't just sit and wait for tranche 2.
Perfect. And remind me, have we identified our next 101 webinar series with you? The topic.
Oh, yeah, you always trap me into this with an audience.
Gonna lock you in. But we will let everyone know there are a few different things that Sarah's working on, and we'll send in the email with the recording, how else you can get involved and different opportunities.
Actually, I would love to hear from anyone who wants to suggest a session or a topic. I'd love it. I'd rather it comes from you.
Perfect. All right. Thank you, everyone. Thanks, Sarah. That was awesome.
Thank you. Bye-bye.